But okay. Yeah, I've seen the order pass, but just because I can't take up. No.
Otherwise, I was also thinking, what amount of cost will be most if the journal is taken by other than the consults.
You want cost imposed on me? Anyway, we'll see. We'll fix it on unofficially, and then it will come up on Wednesday before under the bench. Yes.
That is about
Ah,
motion, item number 12 to 29 about.
yeah. Item 12 to 29, please this case before any other bench without me, huh?
Like,
No, please, Your Lordship. Lord, please note in item 9, Your Lordship.
9.
Yes.
Item 9 is what? Okay.
Your Lordship, here, the petitioner's case is under consideration, Your Lordship.
And
So 2 weeks will be granted, so I can able to obtain the status
who's
report.
for the petitioner? You file. File. Report.
Your Lordship,
Ah,
the last order dated 4/2025. Yes, clearly stated, it is made clear that an endeavor should be made to dispose of the case. On the next written the case, the respondent is not filed as a within 1 month
ah. But then she is saying that it's under consideration.
Oh, yes, Lordship, kindly check my, it's 15, Lordship.
Okay. Heard MS.
It can be so.
Vicon Okisolani counsel for the petition. MS Levical and government submits that the case of the petition is under consideration before the government. And accordingly, prays for 2 weeks time to enable her to receive updated instructions. List of the few hours.
Much.
Yeah, this lordship may I mention for this COP 21 of the may I mention for this?
When is it supposed to be listed?
It is supposed to be listed after 2 weeks, however, it has not listed. And the council is from Gauhati and it's already in Mr. Anshu. If this matter may be listed tomorrow.
Witness the
Lordship.
first.
Lordship.
yeah, it's a lordship. The lordship would like to mention item 30. The lordship, I received one letter from the department.
Hmm.
I'd like to place it on my part, Your Lordship. And Your Lordship, here the department is saying that Annex A, which is the agreement in the affidavit, is not found on record. So they have asked me to seek permission from the Honorable High Court to give a direction for verification by the DC. Your Lordship.
Okay, let it come up when it's called up.
Lordship.
Please, Lordship.
Hmm.
Lordship, I like to mention item number 6, Lordship.
Yes.
And on behalf of the respondents, in this matter, I have received instructions, I'll affidavit the position, Lordship.
Okay.
I will require some more time, so 2 weeks time may be granted, Lordship.
Okay, heard, Mr.
My lords, I am appearing on behalf of petitioner.
Petitioner. In the counsel for the petitioner.
My lords, I am opposing the mention.
You are the standing counsel,
Yes,
then it's standing counsel,
for CBS.
CBIC. Huh? Submits that he has received instructions and prays for 3 weeks time to file a counter affidavit. Praise Allah. Minister.
My lords,
Bring order partially to continue till the next written will.
Sir,
my
Lordship,
lords, the matter may be disposed of by itself. As the matter
Okay.
has already been allowed.
Pleasure.
In a similar matter, the
Wait a second.
impugn order has been quashed, my lords.
Yes.
Here, I'm writing music instructions, so can you
Hello.
please sign off?
My lord, am I audible?
Lordship.
For motion, item numbers 1 and 2. Yes,
Instruction only last night. So I have been trying to make extra copies. All the instructions.
what instructions?
How and why the pensioners were not given the pensionary benefits.
How many of them are not given?
Two of them.
How many of them were in the police case involved?
Almost all the controlling officer as well as the entire.
And they've all been given pensioner benefits,
One of them.
not one, or
Yes, your lordship.
what is the reason for not giving him the pensioner benefits? Oh, you have not been able to sort it out.
Right now, only I.
Okay, we'll take up tomorrow.
Yes.
Huh? We'll take
Hello.
up tomorrow.
Your lordship.
Heard Joshua Shikil and the counsel for the petitioner. Mr. L.T. Sanctum learned additionally Nagaland submits that he has received instructions. Only instructions and he prays for listing the matter. No. So Mr. L.T. Sanctum, additional Advocate General Nagaland submits that he has received instructions. Only now, and he could not go through the same. He accordingly prays for listing the matter on today's what, third, on fourth. Praise a lot, list accordingly.
Thank you, your lordship.
For motion, item number 3.
Lordship, there is a case where the petitioner, despite having served the department for 35 long years as a work charge employee, his service was not recognized and he was currently in the lordship.
He has retired.
This year's retired.
When?
2018,
When did you make your representation?
2024. 27th of February.
27 February,
Yes, lordship.
24.
Yes, lordship.
And when did you retire?
On 31st of February 2018.
31st of February? January, I think.
31st January. My apologies. 31st.
What took you so long to make the representation?
Lordship, I have totally requested because I am somebody
Yes,
who knows,
who is appearing for the other side?
I can hardly write my name.
Lordship, at this stage, not this lordship.
There's already a judgment from the Supreme Court, isn't it?
Lordship,
Covering this matter.
Yes, Lordship.
Let's check it out.
lordship.
Hurts India, level council. Issue notice. MS
Yes, John.
S. Chang, and government advocate,
Lordship.
enters appearance and accepts notice on behalf of the respondents. 1, 2, 4.
Lordship.
Stop. How about 5? Do they have a standing counsel? Accountant General? No,
Yes,
you have to send notice.
yes.
Okay, extra copies. Petitioner to take steps for service of notice on response number 5 by registered post AD within 1 week.
Why not?
List after 4 weeks.
Thank you, Lordship.
For admission, item number 4.
No, please, Lordship. Lordship, you are mentioning on behalf of AIME. Lordship, affidavit has been filed. And I've heard that like, I need the person to be this today. So it to make it can come up after 2 weeks, your Lordship.
You don't have the brief.
I don't have the brief. They've got instruction this morning.
Lordship, if I may, Lordship. Your Lordship, I was seeking for service regularization. Other than the available for by the registered respondents, they have said that mining is been forwarded to the state government for consideration.
No. They said that it's before the finance
Yes, Lord.
for consideration.
Yes, Lordship.
I think you should make finance a party.
Yes, Lordship. But then, since I'm already covered by the OM.
No,
2015.
fine.
Yes.
What they have said is they have already put up to the government for, to the finance department for consideration.
Yes, Lord.
Correct.
Yes, Lord.
Now, unless the finance is met a party,
Lordship.
they will keep quiet. They will do nothing.
Lordship.
So since IMB is asking for time,
Yes.
I'll give her the time. Meantime, we file an implementment application
Yes, Lord.
for finance department so that they can be, they can file the affidavit, give to stamp.
Yes, Lord. I'll do that.
Okay, Participant let me also for petition on request made on behalf of AIME
Yeah.
government. It list the matter up to 2 weeks. For admission, item number 5.
Lordship, there is a peculiar case, Lordship, where after government approval,
How did you file your additional affidavit? With the permission of this court or without the permission of this court?
Lordship,
Did you take the permission of this court to file your additional affidavit?
I believe so, Lordship. Otherwise, Lord,
When?
Otherwise,
How do you
Lordship-
believe so?
otherwise,
I don't
Lordship,
see any orders.
Lordship, for filing additional affidavit in other benches, I have met similar prayers and they said that it is not necessary for
No,
granting permission.
you have to take a permission to file an additional affidavit. Once the court allows, you can file. Just you should make that, keep that in mind.
Yes, my lord.
Yes, sir. You're ready?
Lordship, not accepting the additional affidavit, the additional affidavit cannot be placed on the court as of today, Your Lordship. If they are not relying on the additional affidavit, yes, Your Lordship, I'm ready.
No, you're relying on your additional affidavit because that is the RTI information you got, isn't it?
Yes.
Yes, Lord.
Now, I go to place them on the record, Your Lordship.
When did you file your additional affidavit?
7th of
7th
February,
February.
yes, yes.
You have got a copy of this?
Yes, yes, I've got it. I've got a copy, Your Lordship. However, in order to place this on record, Your Lordship, court has to pass an order as permitting him to place it on record.
Why did you accept the additional affidavit?
No, Your Lordship, therefore I'm saying, Your Lordship, if he is not relying on it,
You have already accepted the additional affidavit. It is in your hand.
yes, Your Lordship.
Then
However, Your Lordship, today, if he is going to rely on it, I was about to make a submission, Your Lordship. Don't yes, file it. This honorable court has not permitted him to file this. Though I have received a copy, I was about to go there if he is relying on it, Your Lordship. If not, Your Lordship, I'm ready with the matter.
it's up to you.
Lordship, we can take it up, Lord.
Without relying on your additional affidavit.
Because Lordship, I have RBI annex in my petition also an extra 147, Lordship.
Mm.
I believe,
That will cover your case?
I believe so, Lordship.
No, be sure. Don't believe it.
Because Lordship, the facts are very simple, Lordship.
No, Angami, what we can do is we'll accept this additional affidavit. In future, he will not do this. And on this basis, I don't know whether you've got the instructions or not.
Lordship, no, I have not sent this copy to the state respondent, Lordship, because I was about to argue on this, that this court has not permitted him. Therefore, I have not sent it.
Otherwise, I'm not challenging those appointments, Lordship.
Yes,
I'm not challenging those appointments.
Okay. Then we'll not rely on your additional
My
affidavit.
lord.
Then we'll reject it. This court is rejecting your additional affidavit.
Then, my lord, necessary order may be passed, Lordship, and we can take it up on another day, Lordship.
Accepting your additional affidavit.
Yes, my lord.
Okay, with a word of caution to you.
My lord.
A word of caution.
Yes, my lord, to be very honest, Lordship, I have faced this same when I was a junior before my lord. So,
Things have changed.
no, Lordship.
The petitioner has filed an additional affidavit.
Lordship, what I just want to say is that, Lordship, different judges express different opinions, Lordship.
Petitioner has filed an additional affidavit without the permission of this court. Stop. However, in the interest of justice, the court is accepting the additional affidavit filed by the petitioner.
My lord.
However, okay, stop. Mr.
And then,
Nangami, London Government Advocate, prays for some time to enable him to receive instructions with regard to the agreements made in the additional affidavit. Praise the Lord. How much time you require?
2 weeks time, Your Worship.
2 weeks.
And give your worship.
For admission, item number 7.
No counter.
Worship, I'm here to receive instructions from you.
Now, heard Subhamati, London Counsel for the petitioner, on request made by S. Chang,
No,
London Government Advocate. How much time?
3 weeks. Worship.
Okay, 2 weeks for the time is allowed to file contract. List of 2 weeks.
Much obliged.
For admission, item number 8.
This is Lordship. Lordship, I am for respondent number 2 in this case. My Lord, before going into the merit of the case, Lordship, I have raised certain issues with regard to the maintainability of the case. Preliminary. So my respectful submission, the preliminary will be heard first, and take only 10 minutes. And if your Lordship is satisfied, then the merit will be closed. If not, then we can go into the merit.
You file your reply, isn't it?
Yes, reply already fine. Reply already fine.
On the preliminary issue?
Yes, we have the issue already fine.
Okay,
Lordship, I'll go straight to my affidavit in opposition.
your respondent number
2.
2.
Malum, this is the writ petition on number 226, challenging the decision of the Washish Court, customary court similarly. Malum, can you allow me to read the preliminary objection grounds, then the reply, then I'll
Okay.
to just to save time. To my affidavit in opposition, Lordship. Malum, page 2 to my affidavit in preliminary. The proponent humbly states that the prayer of the present writ petition is to quash and set aside the judgment in order dated 16/4/2024 passed by the Vipachi's customary courts in the proponent humbly states that with due respect, this honorable court under 226 of the Constitution have no jurisdiction, no power of judicial review to examine the legality of the judgment in order dated 16/4/2024 passed by the Vipachi's customary courts in the. It is also stated that there are serious disputed questions of facts which requires the jail evidence. It is further stated that Washi's court in accordance is yet to be declared as a civil court. As such, this honorable court has no power of superintendence over the Washi's court in Nagaland under Article 227 of the Constitution. It is respectfully stated that without going into the merit of the case, the present subject matter is a property dispute which is purely civil in nature. B. The deponent respectfully states that the mayor previous to writ petition, specifically in paragraph 11 of the writ petition. It is crystal clear that against the judgment in order to the 16/4/2024 passed by the Washi court, the writ petitioner had filed a review petition dated 11/9/2024 before the learned deputy commissioner, which is annexed as annexure O to the writ petition. The review petition filed by the writ petitioner is presently sub judice before the learned deputy commissioner's signature. It is therefore respectfully submitted during the pendency of the review petition. The writ petitioner had no legal right to file this before approaching this honorable court by filing the present writ petition and the same subject matter. The deponent humbly submits the present writ petition was filed without jurisdiction. It is totally civil in nature and involving serious disputed questions of fact and pending before summary. One of them, just the paragraph in the writ petition. Paragraph 11, page 10 to the writ petition. I'm not going to the merit, just to narrate what is the statement of the in the writ petition. After the merit paragraph 11 at page 10. That the petitioner received the judgment order dated such and such only in the month of September 2024 and being agreed for the judgment in order. The petitioner wrote an application dated such and such before the deputy commissioner to review the same. In the said application, the petitioner stated that judgment was passed in the absence It was passed in his absence without following the due procedures of law. Furthermore, the application also stated the matter should be adjudicated by the Assamese village court as per Assamese customary and practices and not by Russia's courts. It would be appreciated by this another report that Navajo have been a patriarchal society. The respondent number 2, however, becomes us only by virtue of marriage. However, the sale is kept in cold storage. Then Lordship, you can see at page 51, this is the application he had filed before the Deputy Commissioner for review at page 51 and next year. Then my lord, to the affidavit in reply.
Yes.
Paragraph 3.
Yes.
Very good. That the answering equivalent needs to state the statements in paragraph 2A and affidavit in opposition is misinterpreted. It will be appreciated the rules for administration of justice 1937 is very clear that district customary court and subordinate district court will decide on civil suits in cases to follow the custom and usages applicable to such suits and cases according to custom and usage applicable in matters not covered by custom and usage. Followed in the district the spirit of CPC to be followed. Furthermore, the present issue is a tribunal issue between a husband and a wife belonging to 2 different tribes. However, the respondent number 1, instead of passing appropriate order direction directed to the Russian court to decide the matter without any jurisdiction, consequently the matter was decided according to Rima customary law. Third, with regard to statement 2B and 2C in the affidavit in opposition, the answering equivalent takes to state that law is settled that the spirit of court is to be followed in respect of matters not covered by custom and usages followed in the district. However, the Deputy Commissioner instead of proceeding the settled position of law allowed that again of the customary number 2 by forwarding to the Pashi's court to try the case being agreed that the opponent wrote a letter dated 11/9/2022-24 addressed to the Seminu to pass appropriate direction as per the law, but the same was kept in cold storage. Therefore, the answering opponent left with no other option but to approach this in the court. This is a reply to my preliminary lordship. Now, my lord, I am citing 2 judgments on this issue. My lord, 1995.
Now, before you come to the Joshua,
Lordship.
the review application before the Deputy Commissioner,
Yes, your
what
lord.
is the status?
Your lordship, nothing has been done. My lord, on this point, in the first place, the semi-customary law and Rima customary law are totally different. And the court, the nomenclature of the court itself is the customary court, your lordship. The Bash is Rima district customary court. So, my lord, when a lady is married to a particular.
No, I'm not going into minutes.
Your lordship.
I'm not going into minutes. The only issue is that we have filed an application before the Deputy Commissioner at Seminu.
Yes, your lordship.
Is it still pending?
Yes, your lordship, but in fact, my lord may kindly appreciate, even that application is also not necessary in the first place. Without jurisdiction, the Lazam Village Council had decided the issue, which is at page 33 of my petition, your lordship. Now, the recourse to the next step would be an appeal before the district customary court. That is either the Poboto ADC court or the Deputy Commissioner's Nevoto. Here, a fresh complaint was again filed before the Rengma District Customary Court in Lordship. So, my lord, when there is no jurisdiction in the first place, my lord, a similar issue has also been decided. The Vashis and village councils have concurrent jurisdiction, my lord. So, my lord, the petition under 226 was examined by this court in the case of Alamturishi Jamir. And there also this Honorable Court held that there is a jurisdiction to appear or to approach this Honorable Court under Article 226.
Okay.
Yes, sir.
My lord, the issue is simple. My lord, when the matter was tried before the Baj's court, he had willingly submitted and contested case in merit. If the petitioner had any grievance with regard to jurisdiction, because, my lord, in paragraph 11 of the affidavit in reply, he had clearly admitted in his rejoinder that he is not raised the issue of jurisdiction before the learned customary court. at the moment when it was filed, after the case was customary court registered the case, if he had objected to the jurisdiction, then he should have approached the appropriate court seeking appropriate remedy. Then the matter would have been different. But in the present case, Lordship, he contested the case and merit. And paragraph 11 of the affidavit in reply, Lordship, you can see, he has clearly admitted he has not mentioned specifically about the jurisdiction. That is what he has also mentioned, admitting in paragraph 11 of the affidavit in reply. So he had contested on merit. He lost the case. He filed a review application. And just because he has lost the case, now he's turning around and challenging everything. That is the issue. So, my lord, the issue before Lordship is with regard to judgment passed by validity. He's challenging the validity of the judgment of the customary court. So, my lord, whether in the present form, whether this court, whether the petition is maintainable. That is the issue, Lordship. Because he has taken a different turn. The moment it is filed, he should have, without contesting the case and merit, he should have taken the appropriate remedy. I have no comments there at the moment. But he contested the case and merit subjected to the jurisdiction of the court. When the judgment is not favorable, he filed a review application, which is maintained. And then, during the pendency of that review application before the Deputy Commissioner examined, he has filed this petition. So I'm specifically going by the law. At the present, under 227, Malad is well aware Gauhati is not a civil court. So in the present situation, whether a writ petition lies under 226. That is my respectful submission, Lordship.
Okay.
I mean, he may have these problems, but then the conduct of the petitioner has to be taken into consideration in the present case. Jurisdiction should have been challenged in the first place. He submitted before the authority. Well, I'm only submitting you short judgments. I'm not. Well, 1995. 1995, 1 SCC 642, paragraph 12 and 13. Malad, the written page 642, 647.
This is not the one.
1995, 1 SCC 642.
These are different.
Or not to bear it.
Yeah.
The contention of the appellant in this appeal is that in the first place, the writ petition should not have been entertained. The writ petitioner had an adequate alternative statutory remedy. The writ petitioner had, in fact, already taken advantage of alternative remedy provided by the statute and had preferred an appeal against the judgment of the tribunal. Well, the said appeal was pending. The writ petitioner invoked the jurisdiction of the Mumbai High Court, praying more or less the same remedy as was prayed in the appeal. We are of the view that the point taken by the appellant is of substance. This is a case where there was not only the existence of an alternative remedy, but the writ petitioner actually had availed of that remedy. The writ petitioner's appeal before the statutory authority was pending. In that view of the matter, this writ petition should not have been entertained. If necessary,
It's okay.
then secondly, 1977, 1 SCC 1, paragraph 4.
Yeah.
The High Court dismissed the writ petition on the ground that it involves determination of disputed questions of fact. It was also observed that the High Court should not, in exercise of its extraordinary jurisdiction, grant relief to the appellant when he had an alternative remedy. After hearing Mr. Chain on behalf of the appellant, we see no cogent ground to take a different view from the from that taken by the High Court, there cannot, in our opinion, be any doubt on the point that the extent of purity of chip SIM owned by the appellant is a question of fact. It is also been drawn to our notice that after the dismissal of the writ petition by the High Court, the appellant has filed a suit in which he had agitated the same question, which is the subject matter of the writ petition. In our opinion, the appellant cannot pursue two parallel remedies in respect of the same matter at the same time. On the merits.
No
Logic. So, my lord,
get those books.
so my respectful submission, my lord, I'm not going to the merit at all today. If on the preliminary ground, lordship is satisfied, then the matter will be closed. If lordship is after review that the merit case has to be examined and merit, then opportunity will be given to the parties.
Yeah.
Your Lordship, may I take your Lordship to Rule 62 of the Rules for the Administration of Justice and Police in Nagaland. Rule 62, Sub-Rule 2 and 3, Your Lordship. Respectfully, Your Lordship, this will clear the picture. May I give my copy to Your Lordship? Because it's just very short paragraphs. It is also reproduced at page 12 of my writ petition, Your Lordship.
12.
Yes, Your Lordship. Page 12 on the top, Your Lordship.
Yeah.
Sub-Rule 2, Your Lordship. I'm reading from the book, Your Lordship. The District Customary Court and Subordinate Court Customary Court in deciding civil suits and cases shall follow the custom and usage applicable to such suits and cases, and shall adjudicate all such suits and cases according to justice, equity, good conscience, and the customs and the usage applicable. So, Your Lordship, as far as the sub-rule 2 of Rule 62 is concerned, there are two customary laws involved. Rule 62, Sub-Rule 2, which I have just read, my Lord.
Yeah. Just something.
Yes, Your Lordship. Page 61, my Lord, I believe. Page 61 of the book.
Rule 62, isn't it?
Yes, Your Lordship.
Yeah.
Yeah, yes. Sorry for intervention, lordship. I think if I'm not wrong, Rule 62A comes within chapter 4A.
That's what I was looking.
Yes, so that has not been notified.
Whether chapter 4A has been
No.
notified.
No. So unless that is notified, that can't be, that has not been given effect to so far.
In any case, Your Lordship.
Where is this chapter 4A?
Customary reports,
It's a
basically
page
customary reports.
51, Your Lordship. 51.
Page 50 of this book.
Yes, Your Lordship. Chapter 4A.
This, if I'm not wrong, unless things have changed in my absence,
Your Lordship.
whether this has been notified.
No, no,
That I was not aware, Your
no,
Lordship.
lordship.
But Your Lordship,
No, if it is not notified, we cannot.
Yes.
but even otherwise,
Has not been given effect to.
even otherwise, my Lord, may kindly allow me. Now, it talks about here there are two different customary laws. Now, in that case, assuming that, now I agree that it is not notified. But Your Lordship, at the point of the submission that I was making earlier, I wasn't aware that it was not notified. However, Your Lordship, it is the understanding of my client that Rule 62, Sub-Rule 3, now where the customs and traditions do not apply,
Joshua,
Your Lordship.
Rule 62, we cannot go into till the 4A is notified.
My Lord. Then in that case, Your Lordship, I'm dropping that argument. But Your Lordship, where two different customary laws are, now the general argument, Your Lordship.
That is one issue.
Your Lordship.
You participated in that.
Yes, Your Lordship.
Basis court.
So, how will a person who is before the court know which law is going to be applied? Where two different customary laws are clashing, Your Lordship, CPC is to be applied, Your Lordship.
You're the husband.
Yes.
Yes, I'm the husband.
You belong to a different tribe.
I belong to a semi-tribe.
So I'm not using the name of the tribe, but
Yes, Your Lordship. Yes, Your Lordship.
your wife belongs to a different tribe.
Different tribe, Your Lordship.
All right.
Yes, Your Lordship.
Property is situated property is at Sumin.
Properties at minimum.
Yes, your lordship.
Anyway, at that time you could have said that, no, see, as per Naga customary law, I've married her. She now becomes my tribe, and therefore your court has no jurisdiction to try me.
That issue is also there, your lordship, but what about the first decision that was given by the Lazam Village Council? Whether the Dobashi customary court Siminu with a concurrent jurisdiction could have tried the matter, and if it is to be tried, your lordship, CPC, the spirit of CPC is to be applied.
No, you will, who is that? I've forgotten this rules. There's already a.
Hello.
Let us do one thing.
Hello.
We'll take it up on Thursday. Not tomorrow and day after I have some difficulty.
Thursday, your lordship, I have difficulty in my, there's a marriage in my family, your lordship.
It's a marriage season.
Because
Yeah,
another issue is this, lordship.
Now that rule 4A has come into pic.
No,
has,
my lord, that has not been notified.
no, that's why. Now,
Why is record sufficient? The issues by Leonard Friend is on the merit of the case.
no, that's why.
So, my lord, whether we go into the merit or not, because, my lord, if it is maintainable or not maintainable, that has to be decided. Just a preliminary objection has been raised. And thereafter, lordship, if lordship is think that we go into the merit, then we go on the issues raised by my Leonard Friend, we can examine. But there is a preliminary objection.
Your lordship, respectfully, I'm on low points, not on the merit of the case, my lord.
Because it all comes under the maintainability, lordship.
Whether 23A was also followed. Rule 23A.
Your lordship. I'm not aware of that, your lordship. I'm looking at the rule 23.
What do you call this? Moya, you should have some instructions on this. Whether the deputy commissioner Trimini followed 23A.
My lord, after the letter was, the procedure, the due process was followed, the petition was submitted to the deputy commissioner, then it was forwarded. So the due process was followed, where the case was registered. Under merit it is shared. It is crystal clear from the petition, my lord.
Let me go through this.
No.
I've lost touch, in fact, in quite some time. There's one particular rule which deals, I don't know. Yes, Mo, you were saying something?
And somewhere else, chapter 4A, I'm sorry, that is district customary responsibility. This has not been given.
No, that part, unless in my absence, it has been notified, that's a different thing, but so far as I know, it has not been notified for it. So we cannot go into forest.
My lord, lordship, may kindly come to page 36. The writ petition to the Department 23A.
30,
36. To the writ petition.
okay.
The complaint was submitted before the deputy commissioner and then it was endorsed.
Okay, yeah, that's fine. So 23 is possible.
23A for.
When can we take up then, Joshua?
Can we take up next week, your lordship?
No, but next week, please. My daughter will not be sitting.
I'm
How about tomorrow, your lordship?
Tomorrow and after I'm having some problem.
Then why not on Friday, Lordship? It will be short matter if he gets complimentary, Lordship. Is my learned friend have difficulties and next.
Like Thursday and Friday, I went to apply for leave medal. Because it's a matter of my family and I have to be there with them.
Same thing is happening to me tomorrow and death. Otherwise, this issue is quite clever. I just wanted to update myself on this one. There's one gray area which is there, but I just can't recollect that particular.
My lord, if it is convenient, can be here too, then will also, because I came only on maintainability. But then if you lordship want to read that, then
Two, I think I have a VC. I have a VC anyway. Isol bench.
About three, your lordship, because the question also remains whether two concurrent jurisdictions.
no,
give
the
two
question is
decisions.
unmarried. The question, but mother,
That is
I am
also
speaking,
the question of law, your lordship.
I am speaking, lordship. The point is, the issues that my learned friend is facing, it may have certain or the concern of your lordship. It may have some legal period. But then the writ petition in the present form, whether it is maintainable or not, that has to look into my lord, because my lord, before the Conscious Court, he did not challenge the jurisdiction. He submitted, contested and merit, lost the case, filed a appeal. It is pending, rightly or wrongly, and that is sub judice. That cannot be. The court is a local court and cannot be oblivious to that situation. So the any issues my learned friend is facing, whether in the present writ petition, WBC 228, in the present form, whether this honorable court can go into, that will be, the whole character of the case will be changed. That aspect has been taken into consideration, lordship. Because at the threshold, lordship, the writ petitioner has to satisfy my preliminary objection.
Yeah, there are two objections.
Your lordship.
All right.
Yes, your lordship.
And another one is that you have already filed an application before the deputy commissioner.
Yes, your lordship.
I'm not saying review, but I'm saying application.
Yes, your lordship.
Because in your writ petition, if I'm not wrong, subject to correction, I don't think you have said review.
No, your lordship.
Or I don't know.
Well, it is on page 50.
Para 11.
It's an objection. Objection to the judgment and order passed on.
You said, and you wrote an application.
Yes, your lordship.
Now that if that application is still pending before the
Yes.
deputy commissioner, Siminu,
Yes, your lordship.
what makes you come here?
Your lordship, it was
At
the
best,
application was
without
submitted.
entering into marriage, we can direct the deputy
All
commissioner.
these issues raised by him,
That can
they
be
raised before there.
there, and then direction can be given to the deputy commissioner to dispose of it earliest.
That is one aspect of the matter, your lordship. And my lord, I do not know whether your lordship is in touch with the old judgments in Anantamisha Jamir's case also, your lordship. They were
What is
also,
the adjustment?
the preliminary issue was similar.
If that
Yes, your
judgment,
lordship.
that was, I don't know.
Circumstance of the case is not totally same, but it is similar, your lordship.
This is with regard to
The village council court and the Washington court, your lordship. Your lordship, this preliminary issue was referred before the learned division bench. And the learned division bench held that WBC, the writ petition under 226 will also lie. My lord, taking all this into consideration, I have filed a petition under 226. It's not a blind decision to approach the zoning court and confuse the system. Which
but
is not
no,
the system.
but in that petition, there was no review application filed.
Exactly.
Here,
Yes, your lordship.
case
That
is
is the-
different.
That is a slight different circumstance which is in play in this case, your lordship.
It's your own action.
My lord,
You submitted before the Siminu Dubashi court.
your lordship.
you're not happy with that, you filed an appeal, or I don't know, you set an application. So you filed an application before the deputy commissioner.
Similarly,
Before he can dispose of the matter, you've
Yes.
come here challenging the Dubashi's judgment.
because Lordship, after the disposals by the civil deputy commissioner, whichever way, it is always open to him.
That is there.
That is there, your lordship, which I will not deny, my lord, fairly, your lordship. However, your lordship, one of the main concern for coming here before this honorable court was, how can two concurrent jurisdictions pass two different,
That's why that the deputy commissioner, you can place your facts before the deputy commissioner. It's
your lordship,
all these facts.
your lordship.
And then if he passes an order which is not acceptable to you, you have other avenues.
Yes, so without exhausting that remedies.
That's what I'm saying. Well,
Your lordship.
senior counsel is correct on that. I'm not going into his first preliminary objection, but the second preliminary objection, we can give a direction.
Your lordship.
Let him dispose of within a period of 1 month, 2 months, whichever what Moa says.
Then, my lord, if my lord has arrived to that conclusion, I'm not agreed by it, but I have a request which may kindly be considered by this honorable court to place a proper representation before the DC while the earlier objection, so-called objection application is pending, and may be allowed to place relevant facts in the form of a fresh representation before the DC.
No, see, under these rules, where is the scope for representation? You'll have to file an appeal.
Yes, your lordship.
Yes,
So an appeal, a proper appeal, incorporating all the necessary law.
Then I'll do one thing. I'll pass just one paragraph judgment.
Your lordship.
All right. Okay, heard Joshua Shikil, then the counsel for the petition. Also heard Mr. Humayun Chib, then at senior government advocate for the respond number 1. And Mr. Takamasa, then the senior counsel, assisted by
Cindy
Mr.
Law.
Cindy Law, then the counsel for the respondent number 2. Stop. Para. The present writ petitioner. No, the present writ petition has been filed by the petitioner challenging the who was the DB Scott? This is Lazami
no, let's take it all. When it's in the
challenging
second
the
page of the judgment. The repetition
Lordship, page 46 to 50, and next year, and 16/4/2024.
challenging the judgment in order.
Judgment order, no, and lordship, it's just their style of judgment order.
Challenging the judgment dated
16/4/2024.
16/4/2024. Is it?
Yes.
Who is this?
Lordship mechanism, page 46. Lordship mechanism, page 46. It's they're all mentioned there in the repetition, page 46.
No, 16/4/2024 is not there.
Lordship mechanism, see at page 46.
Oh,
The case number is mentioned. Then, my lord, at page 49, on the bottom, the 16/4/24 is mentioned.
okay, page 49. 16/4/2024. Passed by the Dobashi's customary court, Ziminu.
And more particularly, my lord, Ranma customary law, it's stated in the order at page 49, my
I'm not entering into that.
lord.
In case number, column, Miss dash 114, land dispute. You just check page 46. Stop. Para. The respondent number 2 has filed an affidavit raising 2 preliminary issues. Stop. Amongst the 2 preliminary issues, the London Senior Counsel for the respondent number 2 has strenuously argued that after the judgment and order dated 16/4/2024 was passed by the Dubashi's Customary Court, Semini, the petitioner had filed an application dated 11/9/2024 before the,
It's 11/7.
11/7.
is it 11/7?
Yes.
11/7/2024 before the Deputy Commissioner Semini. And stop. However, before the Deputy Commissioner Semini could pass any appropriate orders, the petitioner has approached this court by way of the present petition. And on this ground, the present petition is not maintainable. Stop. But Mr. Joshua Shiki, learned counsel for the petitioner, submits that the petitioner may be permitted to file a recast appeal before the Deputy Commissioner Semini, and the said authority may be directed to consider the appeal and dispose of the same by a speaking order within a stipulated period of time. Stop. But considering the submission made by the learned counsel for the petition, the petitioner is permitted to file a recast appeal before the learned Deputy Commissioner's meeting within the period of 2 weeks. 2 weeks from today. Stop. Thereafter, the learned Deputy Commissioner shall consider the appeal to be made by the petition and dispose of the same by a speaking order and in accordance with law within a period of 3 months. Make it 2 months. 2 months within the period of
2 months from the date of filing.
2 months from the date of receipt of the application of the appeal. Stop. It is made clear that this court is not entering into the merits of the case while passing this. Stop. It's not making any observations on the merits of this case while passing this order. With the above observations and directions, with petition is accordingly disposed. I'll keep this. Let me also see. Yes, send it to my chamber. No, not report.
For admission, item number 10.
The interim order is there, so the script starting.
Okay, interim order stands vacant. Interim is there. Let it be like this. Where is Joshua? Let it continue till the date of filing.
Lodge.
Interim order, I'm allowing it to continue till the date of filing only. After the date of filing, it is the Deputy Commissioner who will take. Interim order passed earlier shall continue till the date of filing of the appeal by the petitioner before the Deputy Commissioner.
Well, okay, we can create the interim order passed by this and report, so that will be.
Okay, interim order passed by this court. Huh?
For admission, item number 10.
Here, somebody was asking for time.
Roger, kindly grant me 3 weeks of time since I'm yet to receive instruction.
You want instructions?
Roger.
Okay. Heard Iron Long and the counsel for the petitioner. Mr.
Achungli.
Achungli, learned government advocate. Is allowed how much time?
3 weeks, Roger.
3 weeks for the time to receive instructions. To file contract.
pledge.
For admission, item number 11.
Previous motion. Lordship, I recommendation on behalf of S. Mary, Lordship. It please kindly grant to me, Lordship, to find my contact with Lordship.
To file your counter affidavit,
I think not this motion.
you have not filed one here. Okay, heard MS. Okay, serial number 2, Vikonokis Learning Council petition. On request made on behalf of S. Mary, Learning Government Ticket. How much time?
3 weeks, Lordship.
3 weeks time is allowed to file counter affidavit.
For orders, item number 30.
Yes. Lordship, this case is a little Muslim and he's engaged before. So this will be passed on for a day.
Heard MS.
Rubika.
Huh?
Rubika.
Okay. Rubika Kihu. Learning Council for the petition on request made on behalf of Mr.
Everyone go. Everyone go ownership.
M. Longkumar, Learned Government Advocate.
Lordship.
When do you want? After a week?
Lordship, tomorrow.
Okay. Tomorrow?
Lordship.
Tomorrow? List the matter.
My lord, I don't have an objection for there is no dispute, your lordship, as far as this letter is concerned. I would be happy if the deputy commissioner is directed to inquire into whether I'm the landowner or not. Because, my lord, over the years since the execution of the agreement, I have not received even a single appointment. So in that direction, may kindly be issued, my lord, in order to shorten the matter and also to know the truth of.
No, but counsel is not there, no? Who is your counsel? The government advocate?
Lordship, everyone go work. He's engaged before quarter 3.
Okay.
If not, my lord, I'm not disputing this letter, so whether the main counsel is present or not, it would not make any difference to law. As a direction to the deputy commissioner to ascertain whether I a land order in terms of the state government policy, my lord.
Where's the state policy?
Noted, this annexing the petition. The agreement was executed in
No. That policy framed by the state government.
Your lordship, at page 31 to 34 of my writ petition, my lord. The type copy is at page 33.
5th March.
3A, my lord. Page 30, page 33, my lord. Type copy. 3A. In other cases prior to 26/7/2005, the subsequent setting up of administrative and block headquarters on freely donated land, where a specific written agreement exists providing for employment to landowner, the claim of the landowner for employment should be settled in terms of such agreement. By this letter, the government is saying that they are not aware of the agreement, which is not on record.
Where's your agreement?
Lordship, it is at page 15, your lordship, annexure A.
Page 15, annexure A. That is not on record.
Apparently, or not on record. Your lordship. That is the reason why.
And then what is annexure B?
Your lordship, it's a land declaration.
Land in question is disputed.
No, your lordship. It is just that it is not on record of the department and the department would like to ascertain through the deputy commissioner, according to this letter which my lord has also received this morning.
No, annexure A is not on record. But annexure B, they're saying there's a dispute.
That is why, your lordship, perhaps the service of the deputy commissioner is required to ascertain this, and I will not be aggrieved if the deputy commissioner is directed by his own court, your lordship, to ascertain the fact.
Okay, we'll dispose. Heard Mr. Joshua Shakil and counsel for the petition. Also heard your name or his name?
Lordship, this is the law that we have everyone go back.
You want that way to be recorded. Also heard MS Pichano.
Lordship,
Leonard, how can two government advocates appear? Okay, I'll record your name.
Lordship,
Also heard MS Pichano, Leonard government advocates. Appearing for all respondents. You don't have to record. Appearing on behalf of the respondents 1, 2, and 3. How about 4?
The lordship, the private respondent is yet to appear, my lord. Respondent number 4 is yet to appear.
He has been appointed.
Yes, your lordship. I've challenged his appointment.
Oh, then supposing if you give a direction to the
No, the lordship, the matter may not be disposed, but the report of the deputy commissioner may be submitted before his own court within a stipulated period, your lordship, so that his own court will get a picture of whether there is any dispute or not, whether I have a right to be appointed and challenge this
Lordship, if
appointment.
it's more than 1 point still, so Lordship may come and ask for the Lordship.
I do not know why my learned friend is so afraid about this.
Okay, since again if that council is not there, then okay, cancel that order. But Joshua Shikil and the council for the petition. Stop on request made on behalf of Mr. M. Kumar and the government. List the matter after a week
My lord,
because you will not be there next Friday, Thursday.
My lord.
Friday.
your lordship. Obliged, your lordship.
For orders, item number 31.
Lordship, I received my instructions, so 3 weeks time in front of the department.
1 minute. Whether service has come back, private respondent,
No,
huh? Who's the petitioner? This also landowner.
Yes.
Then you want to take first steps?
Yes, I'll go to buy a dust.
You want to take dusty service?
Yes.
Okay. Mr.
Mahak. I'm appearing on behalf of the council for the petition.
You know you don't know. You write your name and give it to her.
Okay.
Mr. So and so, learned counsel. Appearing on behalf of Mr. Yushitamchan Pomono, learned counsel the petition. Praise for taking first steps for service of notice on the respond number 6 by dusty service through the registry of this court. Stop. Prayers are not. Let such steps be taken within a period of 1 week from today. Stop. Draft petitioner shall file an affidavit to that effect. Stop. List after 2 weeks. This one, let me.
It's a possibility that one's.
Wait.
Yeah, that's all I'm getting. Kalibias. Ngồi chưa? Lọt cho kiểu thì đó, giờ nó lốm na tay chăm nó vào.
You see. Ah. Oh, no. No problem.